But at this moment, so this is how the court look at this very moment.
Brief summary on the court proceedings today. Of course, you know that today the petitioners and the respondents are in court today to finalize and finish the presidential election petition tribunal that started ever since INEC decided to rig the election. I'm going to take you through on what's conspired in court and what happened in court. Of course, LP is making a case for themselves. The legal team, all of are here. The People's President and the People's Vice President, that is Peter Obi and his vice, they are all in court. Justices are here. Counsel's appearance are being taken. H.E. Peter Obi, Dr. Dati Baba Ahmed, Prof. Chimamanda Adichie, Chief Akin Osuntakun, Barrister Julius Abure, Mr. Oseloka Obaze, and other notable LP stakeholders are in court. Dr. Livy Uzoku SAN is leading our legal team today. HE, His Excellency Peter Obi, standing for the petitioners. Chief Lateef Fabemi SAN announced for APC with others, SANs and non-SANs. The matter slated for today has been mentioned as adoption of final written address by parties. That of Atiku and the PDP was done from 9 a.m. till about 12:15 p.m. earlier today. So the matter slated for today has been mentioned as adoption of final written address by parties. Court is filled to capacity. Lead counsel to INEC, AB Mahmood SAN, announced his appearance alongside his learned colleagues. Chief Wale Olenipekun is announcing his appearance. With him are other members of the outer and inner bar SANs and non-SANs. Court begins. We will begin with the objections before we come to the main written addresses. AB Mahmood. AB Mahmood, this case is different from the earlier case because the petitioners here also raised objections. Chief Livy Uzoku, we prefer for them to start. AB Mahmood. My learned friend Stephen Edehi will lead these procedures. AB Mahmood speaks. Stephen Edehi SAN for INEC. Stephen Edehi will be representing INEC. Stephen Edehi, the first respondent, INEC objection on admissibility of document in evidence was filed on 14th July 2023. We also filed a reply on point of law on the 28th of July 2023. We adopt the content of the said written address. Court indicates there's an error. Stephen Edehi continues. We seek leave to correct that line. Reads it to read, which do not have. Court, correction done. Stephen Edehi. Thank you, my lord. I adopt the same process as our argument before this honorable court to sustain the objections. Chief Olanibekun, court. Olanibekun, the court calls Olanibekun. My learned brother Yusuf Ali will conduct the next proceedings. Yusuf Ali SAN represent Bat and Shettima. The argument on objections of the admissibility of document was articulated and filed on the 14th of July 2023. Upon receipt of the reply of the petitioners, Labour Party and Obi, it became imperative to file a reply on point of law, which we did on 25th of July 2023. We adopt these processes in urging my noble lords to sustain the objection and strike out the inferred document before my noble lords. L.O. Fabemi SAN representing INEC begins. We feel our written address in respect of the objection filed on 14th day of July 2023. We also filed a reply on point of law on receipt of the petitioners. Reply address dated 27 July but filed on the 28th of July. we adopt our argument to reject or discountenance those documents. Dr. Levy Uku is already standing. Our Kalu SAN will respond to the processes of the first respondent if it pleases my Lord. Our Kalu is already standing to begin his response. The petitioners have the two processes in response. The first in the reply to the first respondent, INEC. It was filed in the 23rd of July 2023 against the first respondent objection filed on the 4th of July. I adopt the said process as our argument. The petitioner's reply to the objection raised by the second and third Bola Ahmed Tinubu and Shettima was filed on the 20th of July 2023. In respect to the objection by the third respondent Shettima, the petitioner's reply was filed on the 23rd of July 2023. We adopt the petitioner's reply to all the respective parties. Dr. Eliviu Zuku is already standing. Chief Anachebe SAN will take the charge of our own objection. Chief Anachebe is already standing to begin the objection. May it please my noble lords, the objection against document tendered by the first respondent, INEC, was captured in our written address, date 22nd July, but filed on the 23rd of July 2023. There was also an objection filed against documents tendered by the second and third respondent, Shettima, filed 20th July 2023. Chief Anachebe continues. We respectfully adopt the argument canvassed in the two processes in opposition to document tendered by the first, second, and third objection. Our submission in urging your lordships to impurge the said document from your bundle of documents and sustain our objections thereto. Stephen Edehi SAN, who is representing INEC, is already standing. In opposition to the petitioner, Stephen begins. Objections on document. We filed a document on 20th day of July 2023. We adopt the content of the said written address to overrule the objections. The court gave the parties 20 minutes each for their oral submissions proper on their final written addresses. There is a timekeeper who rings the bell, indicates once the period adopted to each party is exhausted. The timekeeper will definitely ring the bell. Moving to the second point in relation to the 25%. First of all, that there's no dispute as to fact. The only issue in relation to the interpretation of the relevant aspect of the Constitution is Section 134, which says that the candidate must score 25% in 2 or 3 of the state and the FCT. Your lordship should not adopt an approach that will result in an absurdity, which the voters in FCT are ascribed superior position than the other voters. We hereby submit our arguments. Yusuf Ali, who is representing the INEC, is already standing. In reaction to the petitioner's objection on document, we filed a written address filed on the 25th of July 2023 in opposition. We adopt the argument in the document as our argument, especially as there was no further reply by the petitioners. L.O. Fabomi SAN, representing APC, is already standing. In respect to this objection, we have no process filed. L.O. Fabomi speaks. Court says, we will now go to the main address. Instead of 10 minutes, parties will be allowed 20 minutes each to address the court. A.B. Mahmood, representing the INEC, is already standing. The first respondent has filed the final written address dated 14th of July 2023. Along with that, we also filed a list of authority, also dated and filed 14th of July 2023. A.B. Mahmood continues. After we received the petitioner's written address, we also filed on reply on points of law. Filed 28th of July 2023, we also filed a list of authorities on the same 28th of July 2023 with respect. These are the process filed by the first respondent. We adopt same as our arguments in the petitions. My Lord, for all the detailed argument canvassed in our written address, we humbly submit that the petitions in lacking in merit and should be dismissed by the court. I will seek your lordship's indulgence. On page 15 of our written address, we set out the issue for determination. They are listed. I will only speak to two issues. The first issue is issue number B, has to do with the compliance by the petitioners of non-compliance with the provisions of the Electoral Act. The essence of the compliance is with technology introduced by the first respondent. The rationale seems to be appreciated by the petitioners. However, they misunderstood the technologies. The BVAS was used for accreditation and transmitting of results. The IRF portal is a result viewing portal. The evidence shows clearly that the first respondent went to great lengths to ensure that this technology functioned as designed. The application used on BVAS was developed in-house, tested for performance and vulnerability. The data were also hosted on Amazon Web Service, and evidence shows it was the most advanced and secured web service provider in the world. The intention of the first respondent was beyond doubt, both by the petitioners and ourselves. The petitioners have contrived in their mind the so-called electronic collation system, which was prescribed by the first respondent, which they have brought no evidence to show. Although the petitioners consistently argued that the National Assembly and presidential election went on concurrently, but they never showed there was any electronic collation of results in the National Assembly or any other election. What was in place was the manual collation. The second is in response by the glitch. The glitch was orchestrated by human beings to alter the result. The case put forward by the first respondent is that the glitch didn't occur by human effort, but by the normal function. My submission was that if there was human interference on the machines, the petitioners ought to have showed it. If they failed, that argument fails. Also, the IRF portal was for public views and did not affect the result collation. It was only for trust. All the witnesses have agreed on this. All the argument of AWS being faulty or not result in is in a no issue. There has been argument about 18,088 so-called blood polling unit result on IREV. My argument is that this goes to no issue, as those blood results did not in any way suggest that the original copies of the result sheet were also blood. They have not tendered the original copies which are in the possessions of their agent. That compliance of blood results are simply for dramatization from the state of evidence and from the state of all the pleadings before your lordship, which interrupted the transmission for over 4 hours, did not impact the result, and there was no evidence that there was any manipulation of results. Wole Onenekpekun is already standing on his feet. The second and third respondent filled their final written address on 14th July 2023, also on receipt of the process filled by the petitioners. A reply on 21st of July was filled. We also filled a list of additional authorities on 31st July 2023. We adopt these processes in urging your lordship to dismiss this petition. We will also argue anon that it is a gross abuse of processes of court. I will draw your lordship attentions to a process filled by the petitioners, that the petitioners have no final written address. The petitioner's argument is in response to the second and third respondent are not acceptable, and we seek my lord to discountenance this document. I will address a few areas. One is about non-compliance, that the results were not uploaded in real time. Upload to IREV is not part of the collation process for the purpose of declaration of result. as all collations are done physically at the respective polling units and collation centers where results are entered at the appropriate INEC locations. May I refer your lordships to Exhibit X1, which is a judgment of a superior court given at the instant of the second petitioner that the court should declare that INEC should declare result electronically, and judgment was given. The second petitioner, Labour Party, also went to a high court in Lagos and obtained a contrary judgment. The Court of Appeal squashed the judgment, stating that Exhibit X1 squashed that decision. My lords, may we draw your attention to 1371D of the Constitution. The issue does not arise at all. It says he is under a sentence of death. It is a present tense. Know that he was, but that he is presently under. May I draw your lordship's attention to subsection E, that he is sentenced in a period within 10 years. In primary school, we were taught present tense and present participle. The second respondent is not under any fine. The argument in respect of FCT, let me read the provisions of the Constitution, 134 subsection 2. May I make this the submission on vended needs, that what the Constitution is talking about is votes scored, not landmass, and that was what the Supreme Court emphasized in the case of Awolowo vs. Shagari. The second respondent scored more than 1/4 of the votes scored and the FCT. The first petitioner, with all respect, has no locus standi to question the 25% outcome of the decision, as the Constitution forbids him to contest in a re-election, if such were to be the case. Lastly, in the question of the first petitioner breaching the law, we tendered Exhibit RA 18, gave evidence that he was not a member of the Labour Party. You cannot benefit from your own wrongdoing. There is no connectivity between the petition and the release of the parties. May I urge my noble lords to dismiss this petition and urge my lordship to do hold on my bended knee. Fourth respondent, APC. L.O. Fabemi is already on his feet to represent APC. The fourth respondent filled a written address dated and filled on the 14th days of July 2023. There is also fourth respondent reply on points of law, which is dated the 27th day by filled on the 28th day of July 2023. Respectfully, I adopt and rely on these two processes. I urge the court to dismiss this petition. I will adopt the oral submission of my A.B. Mahmood and our leader, Shifole Olenipekun SAN. I have refrained myself, but I have to be mild to say that this petition is ambiguous. The second petitioner has abused processes. They suffered defeat in Abuja and ran to Lagos. They had a short victory, as the court appeal shows the result were disastrous. Unless there is an appeal to overturn the decision of that court, this procedure here is a gross abuse of process. The investigation in an election is to see whether voting took place, the result declared, and collation was done. I will give it to them where they have done well, and that they did not dispute that voting. Counting, collation, and result are the important things. The one at the unit level is the most important. If anyone wants to attack the result, there has to be a polling unit by polling unit allegation and proof. If they are contended that there were contentions with the transmission, it has to be polling unit by polling unit proof, which was really lacking. It is a question of, before you go high rev, you must start low rev. The much touted issue of rerun is a two-horse race between the two leading contenders. Vote wise, which does not concern the petitioner. Section 134 subsection 3 of the Constitution also buttresses this point. Even if you want to do this, your lordship will ask, where was the man who came second? It is one of the reasons why we would describe this as meddlesome interlopers. Disqualification means anybody is qualified except he suffers under the provisions of Section 137, subsection D of the Constitution. It is not a criminal forfeiture. There was no charge, no trial, and no conviction. So Exhibit BA is devoid of the requirement. BW1 in this regard admitted that strictly speaking, there was no defendant for any criminal offense under cross-examination. In any event, evidence abounds that there was clearance given to the second respondent a clean bill of health. The question of the status of FCT does not enjoy any special status as far as elections are concerned, especially presidential election. The second respondent scored more than 25% in about 29 states. That suffice, and to do otherwise will amount to constitutional absurdity. On the issue of IREV, there is no point that has not been decided. The case has been settled by the decision of the Supreme Court in SC/CV/508/2023. It is reported in Oyetola vs. INEC 2023, 11 NWLRPT. This has cleared any doubt in the air as to the position of INEC, whether it adequately conducted the election. No one is perfect, and INEC scored at least 90% in this election. It is now time for the petitioners, Dr. Livy Uzoku, representing the Labour Party. In reaction of the address by the first respondent, Dr. Livy Uzoku is already standing to begin his replies. The petitioners filed their final address on the 23rd of July 2023 in reaction to the final address of the second and third. The petitioners on 20th July 2023 filed their response. Finally, in reaction to the address of the fourth respondent, the petitioner filed their response on the 23rd of July 2023. We seek to adopt the final address in urging my lords to uphold the petition. We want to submit that the respondents have labored in vain to diminish the importance of IREV, and in the case of Oyetola vs. INEC, which may be cited, stated that IREV is part of the electoral process. I refer to all the witness the position of RW1 because I would like to drag them out of their comfort zone. He said, I know that the authentic and statutory prescribed is the IREV portal. They are trying to downplay that an election which 18,088 blood results were uploaded to the IREV is a faulty election. There is something remarkable about this matter. INEC issued CTCs of purported polling unit results to the petitioners. Out of the numbers, 8,103 were blood certified by INEC. Some were blank copies of A4 papers. Also among them, you have pictures certified by INEC. Court cut him short. We are not writing because it is in your written address. Murmuring heads in court because other parties didn't have these issues. When other parties were doing their own, people did not distract them. The court did not distract them. Here we are, they are distracting Labour Party. Dr. Livy Uzoku continues. How can they say they conducted an election properly? It is my respectful submission that a CTC of any document in a result must be an exact replica of the original. They failed to produce the originals of the copies. They certified because it couldn't be any other than blank sheets. Let me go to the issue of fine or forfeiture, which the second respondent talked about. It is not in doubt that the second respondent forfeited $460,000 as proceeds from narcotics and money laundering. They do not want to hear that. We clearly relied on Section 137, subsection 1D, but they are pushing it to another section, E. You cannot make our case for us. The provision says any court or tribunal. It is very clear. My lords, there is the attempt to claim that the first petitioner is not accommodated under Section 134. The submission that in the case of rerun, There's this argument that the first petitioner will not be accommodated. The only candidate who comes squarely within the province of Section 134 3B is the first petitioners. Even if they created wrong interpretation, it cannot work. The case of Awolowo vs. Shagari was cited. Of course, the provisions now of the constitution was not available to interpret that case. Let me quickly refer to what my brother for second and third respondents said, that the petition was abandoned. I couldn't believe this coming from my brother whom I respected. My brother did not urge you to interpret "and" as being the disjunctive. I didn't hear that. I submit with the greatest respect that the petitioners have proved their petition, particularly with the issue of non-compliance. They had no defense. At one point, they said it was the printing toner that caused the issue. At some point, they said glitch could have caused it, but the alleged glitch lasted only 4 hours, but up to 29th of May, they were still giving us blood result of the election. Finally, the petitioners have proved that there was no glitch whatsoever as alleged by the respondent. Court is hereby adjourned to a later date for judgment. This date will be communicated to all parties. Thanks for supporting the Future News. 26 minutes, but what wonderful. I just want to read out everything that happened in court. Will be coming out with the final written address and we explain it properly. Peace.